She didn't even know where his room was. He came by the room about 2 or 3 in the morning after performing or having a party, I don't know. I think it was Victoria's Secret. Came and looked at baby Usher, touched his head, and left. Now, his proposal to this court is that he has the children with him. His statement is that he's in the same room or to sleep with the nanny and the children. Not only do you have Portia Williams, who has directly refuted that, Ms. Raymond has. Her emails. I need information. Where are you? His response, C.C. Duncan's room number. Co-parenting doesn't even work with Mr. Raymond. Not only sole physical and sole legal custody doesn't work, co-parenting doesn't work here. Email after email, testimony. Ms. Raymond cannot even talk to her children for days when Mr. Raymond has them in his physical custody. She is not even given his alias name at the hotel. Oh, he'll give the hotel information, the name, not the room number, the date, the itinerary. Well, he's not going to check in as Usher Raymond. So he doesn't answer his phone. He testified. It may take days, a while for me to respond. I can't respond right off. Well, she testified. He rarely responds. So if in fact he were to have sole legal and physical custody, the effect is to terminate her parental rights. And no one testified differently. If I sound like I'm outraged, I am, because again, I wouldn't even be standing here if it wasn't Usher Raymond. This is his show. What does Ms. Raymond want? Your Honor, she wants what's in the best interest of her children. She wants stability for them. She wants to be free from his control and intimidation so that she can more effectively go from a very good, great parent to an excellent parent, so she doesn't have to deal with his control and intimidation. She wants to be made whole. For a year and a half, over a year and a half, she has had to deal with this case. You heard her testify. She did not want to have to bring her custody petition in October. But she realized she didn't have a choice, because since he was asking for sole legal and sole physical custody, and she knew that the current arrangement had to change, there would be no other alternative, because she hadn't asked for it. She didn't ask for it, Your Honor, she said, because she didn't want to be here. She didn't want to be here. She testified. She tried to work it out with him so many times. She didn't want to be here, and you know she didn't want to be here today. But she's here, and she's fighting. She wants, Your Honor, part of that not being under his control. She's asking this court, Your Honor, to give her the nanny, control over the nanny payment money. It's already in the order. It's already in the order that she gets an amount per month for picking up nannies. She's asking this court, just make him put it in an account for me on the 1st of every month so I don't have to go through this. Portia Williams testified, no problem, when Ms. Raymond was paying her for her Glover children when she was a nanny for them. No problem. Ms. Raymond is asking that she has the same ability for these children, so that it doesn't cause discord with nannies. And also, so he doesn't have control over those nannies and access to them and having them feel like they just want to touch the hem of his garment. Your Honor, part of that control, what she's asking for, a home. The home she lives in is his. She's asking that this court order, as child support, that that home be given to her. That the deed be given to her. Free and clear of any mortgage. Primary physical custodian with final decision making on all 4 issues. He doesn't respond to emails, he doesn't communicate. It won't work any other way. Education, health, extracurricular, social, I believe that's religion. She wants final decision making. Your Honor, she doesn't want her children not to see Mr. Raymond. She's asking that he have standard visitation as every other non-custodial parent pretty much in Georgia has. If Mr. Raymond is in town and is not on his visitation time, she will allow him to see the children. She'll even give him physical custodial time of the children, no problem. Because she does understand that he is Usher Raymond. But there has to be an order here, Your Honor, that sets forth, in case the parties can't agree, he has this date to this date. And if he puts his children first, he may not accept that performance obligation in Timbuktu. He may just visit his children. That's what she's asking for. Your Honor, she's asking for an increase of child support. As you know, Your Honor, she has currently a child support amount of $4,000 per child, total of $8,000. Now, Ms. Raymond is not asking for a $20,000 increase. She's asking for an increase of $1,500 per child. For a reason, Your Honor, you heard her understand, and the evidence is clear. Mr. Raymond is gone for so much of the time. Of course, the expenses with having the children increase. The custodial order is based on parenting time of 12 days for Mr. Raymond per month. But when he's gone for 3.5 months on tour, he's not exercising those 12 days. So, of course, the expenses increase. So she's asking for an increase of $1,500. Your Honor, unrefuted testimony that Mr. Raymond is in contempt for canceling Ms. Raymond's Saks card, her testimony regarding the importance of the card. It's her business. She's a stylist. That Saks card had discounts with it so that she could rebuild her business and be able to move forward with her life. Well, when he canceled it, what does that do? Like she testified, if it's a $1,000 item, she has a Saks card, she might pay $100 for it. Well, when he canceled it, she's got to pay $1,000. That's $900 more. She can't make any money doing that. It affects her business. So, asking the court to find him in contempt and order him to immediately reinstate the Saks card. Your Honor, asking for reimbursement of the nanny expenses. Again, contempt. Because he refused to pay the nannies, because he refused to approve the nannies, she incurred to date at least $34,000 in these expenses. She's just asking for reimbursement of $34,000. Your Honor, she is asking for reinsertion of the clause of no overnight guests while the children are present. He can have overnight guests. She doesn't care. He can have it a million times. She doesn't care as long as the children are not present, as long as the children are not in his custody. She's asking. It's in the best interest of the children. He agreed to it previously. He should have no problem agreeing to it now. But we're asking this court to order it. Your Honor, we're asking this court to award her attorney's fees. Her attorney's fees and costs incurred in this action. Your Honor, as part of those attorney's fees, I am submitting a declaration with an attachment of the attorney's fees, the total amount and costs that have been incurred by the West firm. Also submitting an affidavit for co-counsel, Aaron Clown, for the fees that have been incurred. Your Honor, my client is asking that these fees and costs be paid within 15 days of the date of any order. And Your Honor, the reason for that is that if in fact Mr. Raymond chooses not to abide by this court's order, this court will still have jurisdiction in order for me to file a motion for contempt and seek him to be put in jail. So we're asking for 15 days from the date of this order. Thank you, Your Honor.